Hello everyone, welcome back to my channel. Today in this video we are going to concentrate on the Negotiable Instrument Act 1881. The total sections under this act are 148 and the total chapters are 17, and the recent amendment is the amendment which is made in 2018, and this 2018 amendment inserted like two sections. The first section is section 143A, which gives the power to direct interim compensation, and the section 148 which gives the power to the appellate court to order payment pending appeal against conviction. So even though appeal is pending, the appellate court can order for the payment under the Negotiable Instrument Act. So for the UGC point of view, there is no necessary that you should memorize or study or go through all the 148 section. It is just enough that you concentrate on the very basic and the fundamental sections under this act, rather than going without touching the Negotiable Instrument Act. Going with the basics can score you like 1 or 2 marks at times. So moving on to the important definitions. The first definition, these definitions are provided under the chapter 2, and the first definition is section 4, which is about promissory note, and the section 5 is about bill of exchange, section 6 is check. This is very important. This is a very frequently asked question in the UGC NET. So you should remember section 4 is promissory note PN and 5 is bill of exchange, 6 is check. Now let's go through the words of the Bar Act. A promissory note is an instrument in writing, not being a banknote or a currency note, containing an unconditional undertaking, and it should be signed by the maker to pay a certain sum of money only to or to the order of a certain person or to the bearer of the instrument. So the promissory note is actually a instrument which is in writing, and it does not include the bank note or a currency note, and it contains an unconditional undertaking, and it should be signed by the maker, and it should be about a payment of certain sum of money to the bearer of the instrument. So these are the essentials. This you have to keep in mind, because they may give 4 options and you have to rule out the odd one. Then the section 5 is about bill of exchange. It is also an instrument in writing and it contains an unconditional order. So the differentiation between the promissory note and the bill of exchange is: promissory note is like promise, unconditional undertaking or promise, whereas in the bill of exchange it is unconditional order, and it is signed by the maker directing a certain person to pay a certain sum of money or to the order of a certain person or to the bearer of the instrument. Very similar. And the section 6 is about check. It is said that check is also a bill of exchange, but it is drawn on a specified banker and not expressed to be payable otherwise than on demand. So it should be paid only on demand, and it includes the electronic image of truncated check and a check in the electronic form. So this may be a question in UGC. They will ask that whether the check includes a truncated check and the electronic form check. Okay, so you have to be thorough about this. The next very important section is section 7. It provides about the various parties to the negotiable instrument. The maker of a bill of exchange or check is called the drawer. So in case of bill of exchange and check, there are 3 parties. The first one is the drawer, who makes the bill of exchange or the check, and the second person is the payee. The payee is the person to whom the amount is to be paid. Okay, to whom the amount is paid, that person is said to be the payee, and the another person is drawee. So the person who is directed by the drawer to pay certain amount to the payee, that person is said to be drawee. Now let's see the words. The maker of a bill of exchange or check is called drawer. The person thereby directed to pay is called the drawee, and the person named in the instrument to whom or to whose order the money is by the instrument directed to be paid is called the payee. So in case, I'll give a simple example, like A draws a check in favor of B. In these circumstances, A is the drawer and B is the payee, and the banker which this drawer mentions or direct is the drawee. Okay, that's so simple. Then the drawee in case of need. So in a bill of exchange, the drawer will make the bill of exchange and it will make his signature, and he will also name a person as a drawee, right? In addition to this drawee, if there is another name, that person is said to be the drawee in case of need. Okay, so when in the bill or in any endorsement thereon, the name of any person is given in addition to the drawee to be resorted to in case of need, such person is called a drawee in case of need. So in case the drawee is not accessible, then the drawee in case of need can be resorted to. Then the acceptor. Acceptor is very simple. In case the drawee accepting this bill has made his signature to the bill of exchange, then he is said to be the acceptor. In case the drawee in case of need has made his signature, he is said to be the acceptor. So after the drawee of the bill has signed his assent upon the bill, or if there are more parts thereof than one, upon one of such parts and delivered the same, or given notice of such signing to the holder or to some person on his behalf, he is called the acceptor. Then the acceptor for honor. So a bill has to be accepted by the drawee or drawee in case of need. In case they have not accepted it, the somebody in order to honor the drawer can come into play and they can accept it. So such person who comes to protect the honor of the drawer is called the acceptor for honor. For example, if father is the drawer and nobody accepts the bill, in order to avoid the liability of the father, this daughter or son may come into play and they may accept the bill. So that person, the daughter or son here, is called the acceptor for honor. When a bill of exchange has been noted or protested for non-acceptance or acceptance for better security, and any person accepts its supra protest for honor of the drawer or any of one of the endorses, such person is called the acceptor for honor. Okay, now moving on to the next section. So apart from section 7, section 8 and 9 also gives about the parties. Section 8 is holder. So holder is a person who has the instrument in his possession and also who has the legal title to receive the money mentioned in it. Okay. Now let's go to the words. The holder of a promissory note, bill of exchange or check means any person who is entitled in his own name to the possession thereof and to receive or recover the amount due thereon from the parties thereto. That the note, bill or check is lost or destroyed, its holder is the person so entitled at the time of such loss or destruction. So the person who is entitled for the possession or to receive the amount or to recover the amount from the parties is said to be the holder, and in case the negotiable instrument has lost or destroyed and the person who is entitled before the time of loss or destruction is said to be the holder. Very simple. Then section 9 is holder in due course. So this person, I'll put it in the simple words like this person has got the instrument from some other person for some consideration and also in good faith, believing that there is no defective title in the bill of exchange or promissory note or else check. Okay, also he had got the instrument before the due date which is mentioned in the instrument. Okay, if he has fulfilled these three criteria, he is said to be the holder in due course. Now let's see the barrack wordings. Holder in due course means any person who for consideration, the first essential, become the possessor of a promissory note, bill of exchange or check, if payable to the bearer or to the payee or endorsee thereof, if payable to the order, before the amount mentioned in it becomes payable, that is before the maturity date, and without having sufficient cause to believe that any defect existed in the title of the person from whom he derived his title, that is good faith without knowing the defective title has bought, then that person is said to be the holder in due course. Then moving on to the payment in due course. So if the payment is made according to the terms which is very much apparent from the instrument, and also in good faith if the payment is made without any negligence but to the right person who is mentioned in the instrument, then that payment is said to be the payment in due course. Okay, now let's move to the wordings. Payment in due course means payment in accordance with the apparent tenor of the instrument. Okay, so what was given in the instrument, to them that it was paid, and in good faith, the second one, in good faith and without negligence, third point, to any person in possession thereof under circumstances which do not afford a reasonable ground for believing that he is not entitled to receive payment of the amount therein mentioned. So there is no doubt whether he will be entitled or not. So he made the payment, then that payment is said to be the payment in due course. I think this is enough for the video one. The rest of the definitions is explained in the second part, and the other important miscellaneous provisions with regard to the negotiable instruments are provided in the third part of the video. Go check and be clear on this Negotiable Instrument Act. Thank you.